Today, we're going to be chatting in Idaho about Bryan Kohberger. I started seeing these headlines and questions in the chat a few days ago, and I was like, what is everybody talking about? And then I went back through the docket, and all of the written things that happened in court are on the docket now. So if you watch that day in court with us on the Kohberger case, you have seen these things, even if you have not seen them yet in writing. So we are going to go through what has been written out, which is going to include the factual basis that the prosecution read. It's going to include what Bryan Kohberger signed and the plea agreement that he signed. We're going to go through those. Then we're going to get to the fight over the non-dissemination order. Remember in court, the judge said, well, the plea's been entered. I think we can lift the non-dissemination order. And the prosecutor was like, no, please don't do that. And I'm like, really? That's weird.
Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through sentencing.
All right, I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn.
It should be lifted next Wednesday when this comes to a full day, maybe a day and a half, I suspect, for the sentencing hearing with impact statements and what have you. But it seems that waiting is not going to be sufficient. But also I've seen tons of these headlines about signed confession, and then some people saying Bryan Kohberger did not confess. And so I think we need to have a conversation about how we maybe use that word, because saying, yes, I did the thing, I really categorize under that line of confession, though it seems that there are some that use that for, well, this is in the context of a plea deal, and so he's taking a plea deal, that's not a confession. Now, on the other side of that, I'm like, well, if you don't want to confess to a thing and you're taking a plea deal, then there's other types of pleas for that. Those wouldn't have been available here. But there's other types of pleas for that, saying I'm taking a plea deal, but I'm not admitting to responsibility. That's not going to work in this case. This is the signed plea agreement. You'll notice it is signed by Bryan Kohberger. It is signed by the attorneys, and it was stipulated on the 30th day of June. So right as we started hearing the rumblings about this is the day they signed it. We had wondered if this was signed, sealed, and done on that day. I said, yes, there is room for him to perhaps get to court and be like, no, I don't think so. Sometimes these agreements are done verbally. They did this in writing, which means Ann Taylor and the other defense attorneys would have gone to the jail and gotten Bryan Kohberger's signature and made sure that this was locked, and then told the victim's family. So that's why we saw all of this coming out on the 30th. So Ann Taylor's signature, Bryan Kohberger's signature, attorney Bill Thompson and attorney Ashley Jennings, they indicate that they signed afterwards. So the defense signed this first, and then it went to the prosecutors. So also, I'm sure lots of people have comments, questions, thoughts on Bryan Kohberger's signature. Again, there's so little we know about this case. Everything is going to get looked at. I don't know if he signed this while cuffed or not cuffed, so I don't have many thoughts about it because I don't know if he signed that cuffed or not cuffed. It's possible that he was cuffed to sign that. This is the plea as it reads. Defendant Bryan Kohberger, the defendant's attorney Ann Taylor stipulate to the following plea. Defendant will enter guilty pleas to the following counts: burglary and then the murder counts, as stated in the indictment. So the full murder count. Defendant will be sentenced to 10 years fixed, count one, period. Fixed is done. The defendant will receive fixed consecutive life sentences after the other. A lot of times we will see this in cases that are going up on appeal in case there is an issue with one part of a case, or when you have multiple victims, if there's something overturned as to one victim but not another, you have backup sentences. The state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. Defendant understands A, the nature of the charge in which the defendant agrees to plead guilty and acknowledges that he is not being coerced into entering his plea of guilty. He will acknowledge and understand and acknowledges the consequences of pleading guilty, including the maximum penalties that may be imposed and any mandatory minimum penalties. And this is standard language. This is just boilerplate language. And that C, by pleading guilty, he waives his right to a jury trial, to confront accusers, to refrain from incriminating himself. Because he's incriminating himself by pleading guilty, he's saying he's guilty, so he's waiving his Fifth Amendment right. Defendant further acknowledges that he is satisfied with his legal representation, has reviewed with his attorney all possible defenses. I mean, all. And by his plea of guilty, he is voluntarily waiving those defenses and all claims based upon his constitutional rights. You don't get to argue you didn't have a good lawyer. You don't get to argue that this is cruel and unusual. You don't get to argue that you have a Fifth Amendment right not to incriminate yourself. You don't get to argue all these things. Defendant understands that if were to proceed to trial, he would have the right to appeal, including but not limited to A, any issues decided by the court prior to the defendant's guilty plea, including any ruling on the admissibility of evidence, B, the judgment, including the finding of guilt, and any issues regarding the guilty plea. It would be the guilty finding. That's a typo. And C, the sentence. Further, the defendant understands that if were to proceed to trial, he would have the right to file a motion under Idaho Criminal Rule 35 seeking a reduction of the sentence. The defendant hereby knowingly, voluntarily, and intelligently waives all rights to appeal any and all issues in this case and waives the right to file a motion pursuant to Idaho Criminal Rule 35. This is the entire agreement and understanding between the parties. That is the plea agreement that is now memorialized on the docket. That was given to the judge before the plea hearing that we watched. This was not signed by Bryan Kohberger, it seems, until July 1st. This basically lines out the plea and the indictment. So this is the indictment, and this is what we saw the court read in when he pled guilty, because he said yes to each of these steps. And then I plead guilty to counts 1, 2, 3, 4, and 5 of my own volition is what is listed here. So this is him saying, these are the things that I did for me. I hereby admit responsibility to count 1, burglary, which requires the following elements. On November 13th in Latah County, state of Idaho, the unlawful entry of a residence located at 1122 King Road with the intent to commit the crime of murder. I think this is the first time we have seen them really line this out as intent to commit the crime of murder. In the past, it has been with the intent to commit a felony, I believe. So they line that out very specifically. And then we get through each of the counts, which are the same except for the victim's name. And as to count 2, I hereby admit responsibility to count 2, murder in the first degree, which requires the following elements. On November 13th, 2022, Latah County, state of Idaho, the willful, unlawful, deliberate, with premeditation and with malice aforethought, killing and murder, it should say of, I think, Madison Mogan, and then the same for Kaylee Gonzalez, and the same for Xana Kernodle, and of Ethan Chapin. So each of those are the same, and those are all signed as of July 1st. Motion to be heard as interested parties and motion to vacate non-dissemination order. So these are all the different media entities that have joined in with this. On July 2nd, 2025, they say Bryan Kohberger pled guilty to the murder of 4 University of Idaho students and 1 count of burglary. Mr. Kohberger's plea sharply changed the Sixth Amendment fair trial, First Amendment balance in this case. Agreed. There is no real balance left of not tainting a jury pool. There will be no jury pool. There is no jury pool left to worry about. There is no right to fair trial to worry about. The fair trial has been given and is done. At the request of the state and with the agreement of Kohberger, the court left the non-dissemination order in place until Kohberger's sentencing, which is set for July 23rd. However, they say the non-dissemination order and its infringement on the First Amendment rights of the media is no longer justifiable and should be vacated immediately. Accordingly, a coalition of media organizations, including ABC, the AP, Bonner County Daily Bee, CBS, Coeur d'Alene Press, East Idaho News, Fox News, Idaho Press Club, Ion Media Networks, DBA Court TV, KXLY, TCP Holdings, Moscow Pullman Daily News, and all the other alphabet soup that's going in there, including the Idaho Statesman, etc. There's a footnote on all of the media coalition. The media coalition is largely made up of the same media organizations that were allowed to previously intervene in the non-dissemination order and were granted an opportunity to be heard on other issues related to media access. These organizations once again seek to protect their First Amendment rights. Big coalition of media. Hey, Your Honor, do this. There's lots of us saying you should do this. They respectfully move the court for leave to file their motion to vacate the non-dissemination order filed contemporaneously herewith. Remember, the court has to say you're allowed to be heard. They don't just have the right to be heard. They are not a party to the case, but they have a First Amendment right. And so we will see the media pushing back for transparency, which I appreciate. But there are times when I think the media pushes too far, and you'll hear my criticism of that then. I think saying, hey, we want to be able to do our interviews, there's no rights left to be protected. So when the court balances those rights, the defendant's right to fair trial, he is foregone because he's pled. Continuing on, they say the media coalition further requests the opportunity to present oral argument on the... No. You don't need oral argument on the thing. Ugh, you just need the motion. And I don't even know if the parties are going to oppose the motion. The parties are going to hope that the court just puts this over till after the sentencing in 2 weeks and then lifts it then. The media wants to garner the attention in the next 2 weeks because this is what people are talking about. I think this could be done on written motion. The motion is supported by accompanying memorandum, the declaration of Rebecca Boone and Wendy Olson in support. The court has put on the docket Bryan Kohberger's signed factual basis, which shows him saying, I am pleading guilty and admitting to the burglary and the 4 murders signed by him on July 1st. We have seen the plea agreement now put on the docket, signed by Bryan Kohberger and his attorney on June 30th, signed by the prosecution after that, because it went to the defense first and then to the prosecution and then to the court. We know that his sentencing is going to be a fixed life sentence. I have seen some confusion about the fixed life sentence, but from all of the law that I have gathered and everything I have looked at, fixed life means life. No opportunity for parole, no opportunity to ask for parole, and he waived his right to ask for reconsideration. He waived his right to ask for someone to consider this sentence differently down the road. So the way I read Bryan Kohberger's sentence is life, fixed, period, life, life, then life, then life, then life, then 10 for the burglary. That's how I read his sentence. I know there is some confusion on that, but it says very clearly in the plea deal, fixed life sentence, which means the sentence is fixed at life. And there is nothing he can do. He is waiving all of his rights to contest that. That's what he has agreed to. We have seen Bryan Kohberger's signed factual basis, his admission or confession that he did all of these crimes. We have seen the plea deal. We have seen the fixed life sentence. And then we have seen that the media is like, okay, well, Bryan Kohberger no longer has a right to a fair trial because there's no trial. He expressly said that he understood and waived those rights when he pled. He was asked about his right to fair trial, his right to confront and cross-examine witnesses. He said he understood and he waived and gave up those rights. So now that Bryan Kohberger has waived and given up those rights, there is no jury pool to taint. There is no concerns for his right to a fair trial. So the media is saying we should now be able to ask whomever we want to ask for an interview to give comment. We should be able to be free from the non-dissemination order. We'll see what the court does. I'm going to keep you posted. If things happen with this between now and sentencing, I will update you on the app, on the podcast, because I'm curious to see what will happen. I also kind of want the heads up if we're going to see a deluge of more information. We also know, based on the defense's motions, there are books set to be released. There are docuseries that are releasing, have been released, and will be released. So there is a lot of information that's going to come out about this case. But the non-dissemination order being in place at this point doesn't seem legally justified. This court is particular about the law, which I appreciate. Judge Hippler doesn't just do things to do things. And so this request might be well taken and it might get rescinded. Seeing that that got filed July 2nd, we're on July 10th. I'm surprised there's not more on the docket about this in that period of time, truly. So we will see where this goes, or the court's going to be like, the court's bogged down with other cases. Oops, we didn't get to it until the 23rd. And then it's completely moot and withdrawn on that date. I think the media is trying to get ahead of that, as the interest in this case will continue to crest until that sentencing date. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.